Hello everybody and welcome to Legal Concepts, educational videos for the study of law. This video is looking at the case of Poussard and Spiers 1876, and it's recommended that after this video you listen to the case of Bettini and Guy. Poussard and Spiers is a seminal case which illustrates that a breach of a condition must go to the root of the contract and that it can entitle the wrong party to terminate the contract and claim damages. Madame Poussard was an opera singer and she'd been contracted by Spiers for a number of performances in the London Opera House. She received a letter of engagement, a kind of contract of employment, stating about the time, the payment, and the duration of the show. However, Madame Poussard became ill just as rehearsals were coming to an end. The Opera House had also put in place a reserve, someone that could pick up Madame Poussard's performances if need be. However, as the opening night came nearer, Madame Poussard was still very ill, and for the first 4 performances she couldn't perform due to this illness. When she finally became well, she wanted to return, but the Opera House refused her and said that they no longer needed her and that her replacement would be taking a permanent position on within relation to the series of shows. On behalf of Madame Poussard, her husband claimed wrongful dismissal. The question was Madame Poussard not being able to perform for the opening shows a fundamental breach, i.e. a condition, which would mean that the wronged party could terminate the contract as they did? Well, it was held that Madame Poussard not being able to perform on those opening nights did go to the root of the contract. It became a fundamental term because critics were going to be there. The reputation of the show would be formed on those opening nights. Therefore, her engagement could be terminated because it did go to the root, to the heart of a contract. So compare and contrast this with Bettini and Guy, whether this was held that Bettini not being able to turn up for rehearsals was a breach of a warranty. The distinction always is, and the question you must ask yourself, does that term that's been breached go to the root of the contract as to why it was formed? If so, then it can amount to a condition. I really hope that you liked listening to this video, and please subscribe to this channel. The more people subscribe, the more videos I will make, and you can also leave comments as to videos that you would like on certain cases or certain aspects of law. Thank you for your time.